It's bigger than you. It's bigger than me. It's bigger than all of us.
Sir, you're charged with
I was told
especially
counsel wanted to see me
aggravated
in timeout.
kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
It's bigger than you. It's bigger than me. It's bigger than all of us.
This is the next search on February 28, 2020. 7:44 p.m. How does the FBI find people? And people is misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do you need to see?
Scratch all that. Oh, that was terrible. I apologize.
All right, welcome back. Welcome to the Court of Public Opinion. Oh my goodness, I'm struggling. I've got music in one ear and the judge in the other. I'm trying to talk, and you guys are playing all the sound effects. Welcome back. Welcome back. We are going to be returning to the Karen Reed trial here in just a minute. I am the Recovery Addict. Welcome, welcome. We have over on Top Mark Media live coverage of the Brian Koberger final pretrial hearing conference thingamajig right here. Judge is laying down the law. So he's going through some of the evidence. He's talking about witnesses. There are going to be some witnesses, specifically law enforcement witnesses, that are called and then brought down and called and brought down. And he says if one of them is not available for cross-examination when it's time that the defense gets to cross-examine, we're striking all their testimony. So they've been warned. They've been warned. Kim. Oh, here we go. Kim, welcome. Welcome. You're first in chat today. Congratulations. The internet is all yours. Oh, let's see.
Are we going to address subject matter jurisdiction?
Virginia,
I was told counsel wanted to see me inside back.
When you guys are done, I'll talk. No, I'm just kidding. Don't make me stop this car. I'll turn it around right now.
Happy birthday. You look good.
All right. Do you guys got it out of your system yet? I'm trying to talk here. I love it. There's a problem with the Idaho courts feed. When they go on break, it periodically just freezes and doesn't tell you it's frozen. So it came back, and I missed a minute or two of it. Refreshed it. Brian Enton, his live feed on News Nation, they still think they're on break, and we've been back for over 10 minutes. People just don't realize that the feed is not working properly. It's just not working. Like this is, I'm not sure if you can see this. Look at this.
The zombie apocalypse may be upon us.
News Nation has got the live stream from the court, and it says the court is on break right now. That's live. That's live in the corner.
I was told counsel wanted to see me inside back.
It's lots of big channels that are following this are not able to follow the BK trial because something's wrong on their side. It's just maybe it could be the demand, the load on the server. So many people are trying to watch it that it just can't handle it. So hopefully they get beefed up before trial, because that puts a huge burden on those of us that are using that feed to rebroadcast, because we have to refresh every 10 minutes. All right, DMB, gotcha. Tisha, you're done. You're done clicking all the buttons. Everyone's got it out of their system. What is the AT&T one? Which one is AT&T, Tisha? The zombie apocalypse?
The zombie apocalypse may be upon us. The zombie apocalypse may be upon us.
Whoa, AT&T doesn't have a timeout?
I think I'm
about to catch a whooping.
Somebody is. Somebody's about to catch a whooping. All right, we're going to be coming back for lunch. That's not the stream we see.
I was kicked back, taking it easy.
Oh, that my stream's working, but like News Nation, well, now my stream froze. Just like that. It just
I'm
froze.
not going to argue about semantics here.
Have them send someone with more experience.
They've got such a high demand on the server that it just is not working right.
You're talking about stuff that is not relevant. I'm not a cat.
Hang on 1 second. Okay, I've got to have words with the court.
I was told counsel wanted to see me at sidebar.
I'm going to have words with the court because this is bad. All right. We're going to be back in court in just a minute, and then I'm going to turn off these sound effects. Bird flew into my window on lunch break. I think it was a mockingbird, a baby one. Left feathers on the window, on the glass, and I thought, those feathers are stuck to the window.
Sent me a video of roaches fighting.
As if by static. I wonder if snow landed on them, if they'd still be there. And then I thought, no, that's absurd. All right, stone houses. Not sure what I should write, so I'll settle with good afternoon, everyone. Stone houses, that's great. Congratulations on 2 months. Thank you for your support. Love it. Welcome to the gallery. All right. A mocklet, a mini mocklet was what it was. It's a marking bird. Sarah, you were thinking the same thing I was thinking. All right, we just have a couple minutes, and then we should be back in court any second now, actually, because usually it's at 1:45 or so that we come back, give or take 15 minutes. A mockingbird. There's a soft R. A ha-ha bird. Did it die? No, it flew away. It was a baby one. It lost a couple little feathers, but it landed in the bush and then it flew away. We need a Chloe Bark soundbite to cover semantics. You are unmuted.
Enter your.
All right, so I'm told you want to see me. I'll see you at sidebar.
Followed by pound.
I was told counsel wanted to see me at sidebar.
Yes, counsel wants to see you at sidebar. What are you doing tonight since you don't have a podcast? I've got a friend who, actually, this is great news. The cancer treatment worked. His cancer treatment. He still might need like part of his esophagus and stuff removed. But the cancer treatment, the chemo, seems to have worked. But he had a pool in his backyard, and the pool got destroyed by a windstorm. Believe it or not, because it was empty at the time. And it left a big impression in the back of the pool. And we're going to turn that into a back patio. We're going to lay sand and some pavers and maybe a little fire pit. So a group of friends are headed over there tonight to go get that done. So trying to help him out. But big news that yesterday he just let us know that the chemo worked. Sorry about your esophagus, but here's a fire pit. He asked for it. You know, it's his choice. And so if it helps, it helps. Do you ever wonder if she asks how their lunch was at sidebar? How's your lunch, Mrs. Reed? Miss Reed? Miss Reed? Do you have a good lunch? Did you head down to the bar? No? I went to the bar. Are we going to go to the bar after? Not before metal detecting. I should metal detect first. Can we get a sidebar that sounds like an echo into the abyss? Hello, hello, hello. Yeah, Evangeline Light, we're super excited. I haven't actually talked to him since he posted that online, so I'm excited to see him tonight. He's a detective, police detective. Cool guy, cool guy. Let's see. Thank you for all those who have acknowledged the stream so far with a thumbs up, as Buchanan would do if he just gave it a passing glance. I did get some more gear arrived today, and I can't show you because it's stinking heavy. I got a Jackery 1000, which is think of like a substantial personal size cooler. Okay, it's that big, but it's a battery, and it's a battery big enough to run my laptop, the Starlink Mini, Apple TV, a switcher, and what was the last thing? A camera for over 12 hours, which means basically on the road live stream, full power the whole time. Is your slightly suspicious taillight still due to arrive on Saturday? It is, Stonehouses. I'm waiting for that. I run a welder off mine. They're awesome. I have a Jackery just because I wanted coffee when we camped one night. I got it because I'm going to be filming a thing in Virginia here in a month or two. And I'm going to be camping during it. And I need to be able to charge everything. Sarah Sherwood. My husband asked what this trial is about. Apparently I started talking in an accent while telling him about it. I can guess what accent. I've got to be able to charge all my cameras and everything for 3 days, and that should be enough because I don't need computers and that up there. Is Starlink a mini portable? Yes, it is, and it's the plan I have allows me to roam, so I can use it in motion and doesn't void the contract. And it works. I can drive 80 miles an hour and still, well, 70 miles an hour and still get to do a live stream. I'll send you a link to the one I got. Hang on one second. Right, there we go. This is the one I got, but I have to admit, I bought it on a Mother's Day special. Don't tell Mrs. R.A. It was not $749. Even after taxes, it was less than that. I got it for $6 something. What did Brennan just throw in the garbage? Camilla. Oh, that was quick, Camilla.
Oh, the water? I'm good.
All right, here we go. Part 2. Get ready.
Court is in session. Please be seated.
All right, Mr. Lessie, whenever you're ready.
Thank you, Your Honor. Good afternoon, Dr. Scorti-Bello, and welcome back.
Thank you.
I want to move on to a slightly different aspect of the hypothermia discussion. So, you've acknowledged previously that hypothermia is a very difficult diagnosis to make, correct?
Correct.
And you acknowledge that in your grand jury testimony in this proceeding, correct? Do you recall that?
I do.
And you indicated in that grand jury proceeding generally that diagnosing hypothermia is based on contextual clues. Is that correct?
On autopsy findings and investigative information, yes.
Right. And the last part, investigative, and that's that legal part, sort of the law enforcement contribution. Is that correct that you're referring to?
Correct.
You diagnosed Mr. O'Keefe with hypothermia based upon certain medical data that you believe you observed in the gastric area and the pancreatic area. Is that correct?
Correct.
And just for, I think most people will get this, to just be clear, gastric is sort of synonymous with the stomach.
Stomach.
And then we know the pancreas is a separate organ. And in your autopsy, you observed for example, the lining of both the stomach and the pancreas. Is that correct?
I'm sorry, what was the word you used?
Let's start with the stomach. Did you observe the lining of the stomach as part of Mr. O'Keefe as part of the autopsy?
Yes, I observed some hemorrhages in the lining of the stomach.
We'll get to that, right? But I just want to talk about the organs and what aspects of the organs first, and then we'll get to that. And with regard to the pancreas, what aspect of the pancreas did you observe?
I examined both the external surface and the tissues around it, as well as the pancreas itself, by making several cuts.
And there was also a histopathology report that was relevant to both the stomach and the pancreas, correct?
Correct.
Histopathology?
Spell it, Mr. Leslie.
Histopatholgy. So that histopath information informed your hypothermia analysis, is that correct?
The histopathology was done to further confirm my finding or my determination of hypothermia.
So, do I have it correct, and let's start with the pancreas, that you noted the pancreas was congested and diffusely hemorrhagic? Do I have that correct? And you feel free to look at your report, please.
I will.
And I specifically, if it helps, I'm looking at the report of autopsy. It's not numbered pages, but it would be 4. And you see liver, gallbladder, and pancreas is 1, and then you go down a couple more and you see digestive system. That's what I'm focusing on.
Okay.
And the next page is the histopathology.
Yes.
All right. Are we sort of oriented in the same location?
Yes.
All right. So let's start with the pancreas. So if you look at the histopathology page, it says endocrine and exocrine pancreatic tissue with vascular congestion and patchy parenchymal, that's parenchymal, hemorrhage, autolytic changes. Did I read that correctly?
Yes.
And I want to go at these one at a time, so I'm going to jump back to the previous page where you discussed the heading liver, gallbladder, and pancreas. Do you see that?
Yes.
And you see the last sentence says the pancreas is congested and diffusely hemorrhagic. You see that?
Yes.
So now what I'd like to do, and is that what you're rooting in, if you will, the analysis of hypothermia?
The determination of hypothermia was made, yes, based on these findings and the circumstances I was provided. Yes.
Right, and thank you. I'm going to get to the circumstances, but it's sort of the medical legal construct that we were talking about. I want to just start first with the medical, if that's okay with you.
Yes.
So then let's now move to the organ of the stomach, a synonym gastric in terms of your report. So let's go to, please, back to the histopathology section. And under that, under pancreas is stomach. And there's a bulleted one sentence that says gastric tissue with vascular congestion and focal mucosal hemorrhage. Did I read that correctly?
Yes.
And then let's go back, as we did with the pancreas, for the stomach, go back to the previous page in your report under the heading digestive system. And the second sentence states the gastric mucosa shows focal areas of linear hemorrhages. Did I read that correctly?
Yes.
So we've got hemorrhage discussion with the pancreas. We've got hemorrhage discussion with the stomach and the gastric area. Your diagnosis of hypothermia was not based just on gastric and pancreatic hemorrhaging alone, though, was it?
No.
And you did fairly refer to other circumstances just moments ago in your answer, correct?
Correct.
And we're going to get to that. So that means that your diagnosis of hypothermia was also informed by the information we discussed earlier that was provided to you by former Trooper Proctor in his investigation. Is that correct?
Correct.
And one aspect of that information is that he was found, Mr. O'Keefe was found in the snow, correct?
Yes.
So let's go to the death notification report. Am I generally correct that you were, I'm sorry,
Rephrase it.
I will. Thank you, Your Honor. Do you recall the death notification report in this matter?
I do recall, the very initial first information that comes in. That's the death notification given to our intake staff.
Do you recall the contents of that death notification report?
Would you like me to summarize? I don't recall I don't have it in front of me, but I can tell you what the gist of it was.
Would it be helpful to you if I showed you a document that might refresh your recollection on what that, a document that may refresh your recollection?
She said sure. I
Thanks.
think you heard her.
I did. Thank you, Your Honor. May I prove? Yeah, approach your Honor.
Yep.
Thank
Just
you.
show Mr. Brennan.
Yeah.
Yes.
Dr. Scordi-Bello, what I'd like to do, you can read anything you want, but I'm just going to reference to the section that says circumstances of death.
Yes.
What I'd like you to do is read it to yourself, not out loud, and then when you, just that section up to here, and once you're done, if you could kindly look up and let me know.
Okay.
Dr. Scortibello, did that refresh your recollection with regard to the circumstances of death section of the death notification report?
Yes.
And you could please state now what your refreshed recollection is on that topic.
Yes. The initial intake death notification was made by a physician at the hospital, and it stated that we were dealing with a adult male that was found in a snowbank. There was note of having been at a party. There was some information as to the decedent was walking to a house. There was reference to some sort of altercation or dispute with
Sustain.
Strike.
Jurors, disregard that. Move on with this, Mr. Leslie. With this, but just move on.
Yeah, yes. In terms of the differential diagnosis concept that we were talking about before, based upon your refreshed recollection of circumstances of death as discussed in the death notification report, based upon that, did you consider whether Mr. O'Keefe could have been injured and died somewhere other than the front lawn of 34 Fairview?
Objection.
I'm going to allow that.
He got around to it, and it's allowed this time.
Initially, no.
Let's go to significance, if any, of hemorrhaging of the two organs we were talking about, the pancreas and the stomach. Is it correct that the hemorrhaging of a pancreas can be caused by many different things?
Yes, it is.
And to be clear, you found evidence of hemorrhaging of the pancreas of Mr. O'Keefe in the autopsy, correct?
Correct.
And is it correct before the grand jury, you yourself were evaluating whether the injuries had been sustained in a different environment? Well, let me ask it this way. Do you recall what your testimony was in the grand jury about hemorrhaging of the pancreas and possibilities of injuries being sustained in different environments? Do you recall any testimony on that subject?
All right, I'll see you at 10.
Leslie got a little further with that line of questioning after he's drilling in the room next door. Laid a little groundwork, and now we're just back to a sidebar. Yeah, just a little update on the Brian Koberger situation. The judge just tossed out there, what do you guys think about sequestration of the jury? Whoa! What do you guys think about sequestration? Apparently, the sequestration of the witnesses is going to be a thing. Jury definitely sequestered during deliberations, but not sure about the regular trial. So, no decisions on that one. So hope you're not on that jury duty. That's a long one. 12 weeks. I think we're about to conclude on the Brian Koberger side of things while we're waiting at the sidebar. They're about to conclude for the day on the public side. We're going to get kicked out of the room.
I do have a copy. I told you there's a new administrative order. I'll give you a copy of that just so you don't have to go dig for it.
Okay, so we'll keep I'll keep an ear to that. We are about to get booted. Why did the court freeze? It froze. Everything is freezing. Everything is freezing. I'm not sure why. Give me a second. Let me get this pulled up here. There we go. Fix the audio. We're still at sidebar, waiting for the sidebar to end. Mel, don't judge me. I'm a crappy builder, Mel. All right. Still waiting. Still waiting. BK judge is talking about violations of its order and its special prosecutor and with power to question witnesses and grant immunity. Whoa. All right. With that, it sounds like in the Brian Koberger case. Hang on. Let's go to 8. We're back. Fix 2. There we go. We're back. BK's done and off the record for the day. I'll have to go back and listen to it.
Yes. Thank you. At the grand jury, did you testify as follows? If the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. You recall
That's what I remember.
Yes.
Hemorrhaging of the pancreas can also be caused by blunt force trauma, correct?
Correct.
Hemorrhaging of the pancreas can be caused by CPR, correct? Cardiopulmonary resuscitation?
It's possible.
Do you know what a Lucas machine is?
Yes.
And a Lucas machine is an automated CPR machine, correct?
Correct.
And it's a rather large device, correct? It gets strapped down to the chest of someone. So instead of someone having to exercise, etc., you put on a Lucas machine that goes over the chest and it automatically does the compressions, right?
Correct.
Lucas machines can cause hemorrhaging, correct?
Yes.
And in fact, wasn't a Lucas machine applied to Mr. O'Keefe?
I believe so.
And wasn't the Lucas machine applied from when the first responders came to the scene and he was in the ambulance continually and through when he was in the hospital?
I believe so, yeah.
So, when a Lucas machine is used in resuscitation efforts, you'd actually expect to see some hemorrhaging, wouldn't you?
Where?
In the stomach? In the pancreas? Would you expect to see it there?
Not in the mucosa of the stomach and not as extensive in the pancreas.
Let's talk about and pick the pancreas first. So you would agree that from the use of a Lucas machine, you would expect some degree of hemorrhaging in the pancreas, correct?
Not always.
But it's certainly possible that a Lucas machine causes hemorrhaging of the pancreas, correct?
It's possible.
And now let's move to, and there was evidence of hemorrhaging in the pancreas of Mr. O'Keefe, correct?
Correct.
Now let's move to the stomach. Isn't it possible that a Lucas machine could cause hemorrhaging in the stomach?
Personally, I have not seen it in that context.
But do you rule that out?
I can't rule it out. I can only tell you my experience.
So your personal experience is you don't believe you've seen that, but you can't rule out that a Lucas machine causes hemorrhaging to the stomach. Is that correct?
I don't believe a Lucas machine causes hemorrhage to the mucosa of the stomach.
Right. I'm not yet at the mucosa of the stomach, which is a subset of the stomach, right? You're talking about the gastric rugae.
Talking about the inner lining of the stomach.
Inner lining, and another name for the inner lining of the stomach is the gastric rugae, R-U-G-A-E, correct?
Yes.
So I'm just talking about the stomach in general, not a subset of the stomach. Is it possible that a Lucas machine could cause hemorrhaging in the stomach?
Not in the stomach, around the stomach, in the soft tissues of the torso.
Okay.
I will say Alessi is not getting what he wanted from this witness, and I think he thought he was going to get it.
So you've said that you're aware that Mr. O'Keefe was hooked up to a Lucas machine, correct?
Yes.
And are you aware of the length of time that Mr. O'Keefe was hooked up to a Lucas machine?
No, I am not.
Do you know how many compressions per minute a Lucas machine causes?
I would have to say close to 60.
Would 100 compressions per minute be a reasonable amount of compressions for a Lucas machine to cause?
Sure.
So assume 37 minutes of a person hooked up to a Lucas machine. And assume 100 compressions per minute. That would result in 3,700 compressions from a Lucas machine, correct?
Correct.
That's a ton.
Could 3,700 compressions from a Lucas machine explain hemorrhaging in the pancreas?
You could.
And that explanation could be why there's hemorrhaging in the pancreas as opposed to hypothermia causing hemorrhaging in the pancreas, correct?
Possible.
Did you consider that at all in your autopsy report, the effect of the Lucas machine? Is it written anywhere in your autopsy report?
I do consider changes due to cardiopulmonary resuscitation. The rib fractures that were observed were attributed to CPR. Usually we will see some amount of hemorrhage in the soft tissues, but in this context, with the gastric findings, the pancreatic findings, and the information that he was found in the snow with a body temperature of 80 degrees, my opinion was that those hemorrhages, along with the gastric hemorrhages and his body temperature, were consistent with hypothermia.
My question was, does your report state anywhere the words Lucas machine?
No.
And you agree that a Lucas machine can cause hemorrhaging to the pancreas?
It can cause hemorrhage in a lot of tissues.
But including the pancreas?
Including the pancreas.
If you see hemorrhaging of the pancreas and you believe that hemorrhaging is a contributor to hypothermic deaths, wouldn't you also expect to see Wisniewski ulcers?
I did note gastric hemorrhages.
So the court reporter needs to have a spelling of that. Doctor, can you give us a spelling of that?
Oh,
would you like to give it?
If you'd like me to, I prefer to give it. Thank you. Wisniewski.
Wisniewski.
So
that is hilarious. She
can you
defers.
just tell the jurors what Wisniewski spots or Wisniewski ulcers are?
Wisniewski spots are small hemorrhages, small areas of bleeding in the mucosa of the stomach that are thought to be associated with hypothermia, amongst other things. They're believed to be either a reaction to stress due to the hypothermia or some form of what we call reperfusion injury.
Is it correct that if someone is believed to die, at least in part, from hypothermia, that in 90% of the cases of death from hypothermia, you would find Wisniewski's ulcers?
I do not know the exact number.
Is it that you're not recalling what the percentage is for the percent of cases for death of hypothermia that you would expect to find Wisniewski's ulcers?
I don't.
Do you recall?
Hold on. Move on. The objection sustained. So
Okay.
you're asking it. Yes. Go
Okay.
ahead.
Thank you. There were no Wisniewski's ulcers present in Mr. O'Keefe. Is that correct?
I believe there were.
Can you point anywhere in your autopsy report where the word Wisniewski appears?
I did not call them Wisniewski spots. I called them gastric hemorrhages.
Right, so you didn't use the term Wisniewski and you didn't use the term ulcer, correct? In your report at all?
No, I used gastric hemorrhages under the title of hypothermia.
Do you believe that all hemorrhages in the pancreas are Wisniewski ulcers?
You mean the stomach?
I want to start with the pancreas.
Wisniewski ulcers are, the term is used to describe the gastric hemorrhages.
Right, so I wanted to clarify that. So now I want to move to the stomach.
Okay.
Do you believe all hemorrhages in the stomach are Wisniewski ulcers?
Not all of them.
Therefore, there can be Wisniewski ulcers and not be hemorrhaging, correct? Just by logic?
And not be hemorrhaging?
Correct. You can have a Wisniewski ulcer but not have hemorrhaging.
You could, but ulceration would manifest in what we call hemorrhage, the actual appearance of it.
What I'd like to do now is, Mr. Wolf, what has been in evidence, what I'd like to do is to, with Your Honor's permission, publish some depictions of first the gastric mucosa and then start with that, Your Honor. Publish that.
Court reporter's wishing she applied to a different job
So
right now.
this is the one that we have not introduced into evidence openly, but it's sidebar, right?
What I'd like to do is I'll start out with the one that is in evidence, which is the gastric mucosa.
Okay,
start with that.
What number?
I don't know if Alessi is just trying to say we should win because I'm smarter than everyone else, but he does need the jury to follow along here, and I'm not.
Okay, so that was the one I was referring to that we did at sidebar, not in open court. Okay.
Yes.
It's N right down.
And I'd like to move NN into evidence at this time.
All right. All I'll say about this, jurors, is that this may be considered graphic. You satisfied with that, Mr. Alessi?
I'm satisfied with that, Your Honor.
Okay, Mr. Brennan, you satisfied with that?
Yes, Your Honor.
Okay.
Okay, these are internal autopsy images.
May I, Your Honor?
Yes.
These are pictures of the stuff people are made of.
I'm handing you Exhibit 164 in evidence, and I'm going to also, with the court's permission, have it published on the screen. So whatever one is best for you to look at the screen, please feel free to look at either one. Mr. Wolk, if you could publish 164.
If we take a quick gander back at the screenshot of him handing it to the witness, it looks something like this.
Dr. Scorti-Bello, do you recognize 164 as the, well, you describe what 164 is.
Oh, I've got the replay machine.
This is a picture of the stomach of Mr. O'Keefe after it was removed and opened and the contents were removed. And what you're looking at, this pink-red surface, is the mucosa. That's the lining of the stomach. And you had used the word rugae before. These are the folds. The stomach has a lot of folds. And what you can see here are small areas that are redder than everything else. That's hemorrhage, that's blood. And these are the gastric hemorrhages that I described.
Right, so those are what you just showed. There's darker areas, there's just a few of them. That is what you refer to as hemorrhages, correct?
Wisniewski's was, correct.
Well, you didn't use Wisniewski's in your report, correct? You referred to them as hemorrhages.
Correct.
Okay. So what I'd like to do now is to, if I may approach, Your Honor,
yes,
for the chalk.
He's trying to bust our chops on this, and I'm not sure if it's warranted. Unless he's in deep right here and he's trying to gain some ground where he thought he would get some and didn't. Wants to get a W out of this.
Your Honor, with Your Honor's permission, may I show Dr. Scorti-Bello the chalk that's marked for identification? Is that right?
Yes, and let's see what she answers before we use it for more questions, okay?
Yes. May I hand it to you?
Yes.
Dr. Scorti-Bello, could you please take what's identified as Exhibit M and see if you can identify what that depicts?
Yes, this is a picture of a stomach. Again, the mucosa with hemorrhage.
Just hold for the, sorry, not your fault.
You get used to it after a while.
Your Honor, can we take a break?
Yes. Yes.
Right, the jury.
Okay, so that might be an issue. We might have a queasy juror.
I'll see counsel at sidebar, please.
Clean up on row 2, juror box. Clean up on row 2, juror box. Yeah, I think we got this. This is a lot. Okay, this is a lot for somebody to see, especially right after lunch. I just showed you a little tiny picture, and already people in chat were like, "I don't do that, please, thank you." They've got 2 huge big screen TVs, and they're getting bombarded with that. So, well, we get to have a little break. Everyone, deep breath. Everyone, maybe the jury's got a little walk around, stroll in the park. Maybe breathe some fresh air. You know, do a little bit of that. I've got to ask myself, and ask Mr. Alessia the question: is this worth it? She's already doubled down on basically these injuries could have been caused by a car accident. The big win you got before lunch break, was that she could not rule this a homicide. She couldn't say, yes, this was caused by a car accident. He was hit by a car and died, and this is thus homicide. She can't say that. That's your win. But now trying to use her to go so far as to say, as a matter of fact, these injuries couldn't have happened from a car accident. I don't think you're going to get that. And he's trying many different angles. She's already doubled down, and I think he lost something he thought he was going to win, and he's trying to just regain some ground. And he's not winning yet. He's not. Juror wanted a break. It's his job. He's doing great at it. I mean, I love Alessi. Don't get me wrong. I love hearing him argue. He is one of the best. The way he lays foundation and gets to a question that's been objected to and sustained, and then he's like, but Your Honor, the way he can get back around to that and convince a judge who doesn't necessarily like him and doesn't want to do that to do it, he is phenomenal. His knowledge of the law is excellent. I just don't know if this scoring points with this witness, with the depth that you have to get to, we're talking medical level, third-year medical level type stuff, that's just a guess. I didn't go to medical school. But it's pretty deep. We're pretty deep in the weeds here. So he's trying to suggest his pancreas and stomach had hemorrhaging due to trauma from CPR machine. If you're going down that road, why not trauma from the car? Well, if it's reasonable, here's the thing, Lizzie. If it's reasonable to say those injuries were caused by CPR, then you can say, I can't use those injuries to say, thus there was a car accident, proof that he got hit because he had internal injuries to his organs. So the reasonableness of those being caused by the CPR machine would help eliminate that as one of the factors the jury can consider. To be fair, he's probably laying foundations for their own expert. Hannah, that's a great idea. That very much could be true. He's already sort of preempted the state's expert. The other guy, Mr. Wolf, is it? It's an alternate and a possible reason for the jury. By the way, did medics use the Lucas? Yes, they did. 37 minutes, somewhere between 60 and 100 compressions per minute. 3,700 compressions. Imagine Wreck-It Ralph using a plunger on a toilet. And now make that into a machine and stick the plunger on somebody's chest. That's a Lucas machine. It just pounds the daylights out of the body and doesn't stop. It just keeps going. It doesn't get tired like we do. I mean, after 30 seconds of CPR, if you're doing it right, you're going to start feeling it. You're going to get tired. There's a reason why people rotate out. But it just goes and goes and goes. And yeah, I'd expect some bruising. But the alternative is death. There's a chance this could save you. Lucas has set compressions. It is not 60. Does anyone know the actual? I don't think AI would be the most useful information on that. What does it actually do? We called it the thumper. Lucas' machine is amazing. What they do is incredible. He looks ferocious at work. Yeah, that's why I went with Wreck-It Ralph. 120. Okay, so 120 times 37. Let's do the math in the head. 120, that's 3,000. We'll get rid of those. Now we've got 20 times 37. or 20 times 7, 3,400. What? Math got me lost. I'm lost. 7,400. Does 102, 111, or 120 per minute? Got a call coming in. This might be Denise, our court watcher from the BK trial.
Call from Oatmeal.
Nope, it's Oatmeal. Hey, Oatmeal, how are you doing?
Good, how are you?
Fabulous.
I just wanted to add a little bit of context to the Lucas machine and the rate.
Mm-hmm.
So it's either set compressions per minute of 102, 111, or 120 per minute. And even standard manual CPR that is taught in basic life saving to healthcare providers is 100 beats per minute for compression. So think like the Staying Alive song that you send. So her stating that it's 60.
We will rock you. Is that the same?
No.
The same beat?
Staying Alive by the Bee Gees. Yeah. So her stating that it was set to 60 would be entirely too slow for quality compression.
Yeah, because if you do "We Will Rock You," then it's like boom, 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 and you can't do that.
Yeah.
You can't do that too.
Correct.
The crescendo at the end.
So yeah, I just wanted to add that context for what standard BLS is taught for manual compressions, what the Lucas is set at, and how she was incorrect on what she stated. Yeah. He kind of got her in on that one.
Yep. Awesome. Thank you very much, Oatmeal. Appreciate it.
You're welcome. Have a good one.
Bye.
Call from Denise.
Hey, Denise, are you there?
Yep.
Hey, how are you doing? You're our court watcher up in BK. The public part just ended for the day.
Yes, it did.
We're in a quick break here, so we've got queasy jurors. So, what can you tell us?
Oh no. Okay.
I hear myself really loud in the background, though.
Oh, sorry. Oh, I know why. Okay, better.
Sounds hot. That's what it sounds. I'm just kidding. Go ahead.
Sorry, I had you plugged into my radio.
Awesome.
So that I could hear you, but I guess you hearing yourself doesn't help. So when they go back after lunch, they're taking an hour for lunch. So when they go back after lunch, they're going to be discussing the juror questionnaires and what the questions are going to be. And he said it a couple of times during the hearing, that's all going to be closed. So they dismissed us and said, y'all have a good day. Don't come back.
There was a break before that the judge said was going to be 10 minutes. And
yeah,
I don't know how long it was.
It was not. It was more than 10 minutes.
Yeah. Almost everyone's live stream froze on the court is on break. And so nearly everybody missed some of what happened coming back. And I think the court probably needs to know that their server is not holding up to the demand. And it's locked on us. I think 3 times the stream has just frozen on their end.
I know there was chatter about they're still working out a lot of those kinks since they've switched from YouTube to the direct court site. So apparently they're still working out those kinks, but I can definitely let Sandra know. She's the court administrator for Judge Hippler.
That would be awesome. I know Brian Enton over on News Nation, I think they missed like half an hour because we're just sitting there on the screen that looks like it's working, but it's actually frozen and not playing properly. So.
Oh, wow. Okay. Yeah. Break was about, he said 10 minutes. He didn't come back for like almost 20.
Okay, so we probably missed about 20 minutes then.
So, yeah, either that or whoever was running the live stream forgot to turn it back on.
Oh, it was on. We had to refresh the page and reload everything to get it to work, and so did multiple other channels.
Oh, okay, okay. So, I mean, I've got some notes and you know. So, my impressions and stuff like that.
So the judge sort of led this whole show. He did a lot of talking.
Yes.
But basically, there was a lot of talk about the jury selection process. The questions, they're going to go in the questions here off, out of public view. But the process of how it's going to go, they want a pool of 50 people that have passed the for cause challenge, right?
Correct.
And once they get that,
once they get that 50, then they will be start using their preemptories to strike those that they want to strike.
I didn't hear the number of preemptories they're going to get, but if they've got 50 people, and they're going to dismiss everybody at that point, all the extra jurors. 12 each. That means that no matter what, we'll have a pool of the 20 he wants seated, with 8 being alternates.
Correct.
Man, it's gonna be tight. That juror box is gonna be like cozy.
It is.
Hopefully, some people get sent home or something.
Did anybody catch it? Did anybody catch it? It's going to be a different courtroom.
It will. It will be a different room. I didn't hear which one we're going to, but
he did not say. He did not say. He just spoke about when they toured the courtroom. And I was like, yay!
I'm a little concerned. Because when he talked about the technology that will be used for the stream, he talked about a camera on the witness, a camera on the podium, which is the judge, and one on defense and one on prosecution. And unfortunately, in this trial, we have a lot of photographs. We have a lot of video. And I really, really hope, I'm not sure if the court can be talked to about that and saying, are we going to get the connection? Can we get that same picture that's up on the screen? Because that's going to be crucial in this case.
Yeah, so that those streaming can see the evidence.
Mm-hmm. I mean, we've got hundreds of hours of security camera footage. I'm not sure how much is going to be admitted, but that alone is going to be, just a lot of time.
It is. It is. I will ask Sandra about that as well.
That would be awesome.
Yeah, because he did. He was very specific about where the camera views were going to be.
And I'm happy with the views he's provided. I mean, they're good enough. He's not going to zoom in, but it doesn't sound like I can't. I'm not going to get any better picture, but I could put one of the 4 pictures on the screen. I might even run it so that we can zoom in and see what's happening within each picture. We're not getting any more pixels than anyone else. We're just making the pixels bigger. Helping you see a little better. So
yeah,
we might do that.
Well, Sandra came out and passed out printed copies of the order that he submitted yesterday regarding courtroom decorum and all of that.
Okay.
So
is that something you could digitize and send to me? Is it cover media as well?
Yeah.
Oh, that would be
covers
great.
Everything.
That would be great.
Yeah, I'll send it to you.
Okay.
Yep,
thank you.
I've got it. It's in my folder, so I will send that to you. And then, it looks like other than potentially some quick hearings, like they settled on something for June 18th at 12:30.
Right.
That may just be a quick Zoom hearing between the parties.
They're going to have to agree on a couple things that they haven't reviewed yet, and juror questions are one of them. So I'm not sure if they're going to hammer those out this afternoon. There are a couple things he said, you'll just get back to me on that at this other date. But for being a final conference, it's not the final conference, right? We'd love this to be the last time we have a hearing, and the next thing is opening statements, but that's not going to happen.
Well, so jury selection, did you hear about voir dire? So it won't be live streamed,
right?
For the world to see or hear, rather, but the public will be allowed in the courtroom, and there will be an overflow with closed circuit video from the courtroom for voir dire, for the group voir dire.
For the 50.
Obviously, individual voir dire will be just between the parties in private, and he said they're only going to have 10 to 15 minutes to ask their questions.
That's not much.
For each individual, so they better be prepared.
So that's going to be interesting. The judge sounds very optimistic that they're going to be able to get a group pretty quickly. Now, they're going to have a lot of people subpoenaed, but talk to me a little bit about sequestration, because you mentioned it a couple times, and sequestration can mean the jury and it can mean the witnesses. What did you gather from that as far as the jury's concerned specifically?
Right. So jury sequestration, unless something drastic happens that will require him to sequester them during the trial, they will not be. They will be sequestered for deliberation, and they will be sequestered for the penalty phase.
Okay. We're coming back to court. Denise,
okay.
Thank you very much.
That's
I can't
fine.
wait to talk to you more about this. I'm so excited. This case is getting closer. It's getting so good. Thank you for being
I'm going to
there.
try and come for at least one day of voir dire, because I've never experienced that before, so I'm excited for that.
Awesome.
Please be seated. Court is in
Thank
session.
you very much. We'll see you, Denise. I've got to go.
All right. Bye, guys.
Bye-bye.
All right, Mr. Alessi, you can continue where you left off.
Thank you, Your Honor. May I reapproach the witness?
Yes.
Dr. Scordi-Bello, you have in front of you, which has been marked for identification as MM, and you were discussing that. Do you recognize that document since it sort of started over to reorient the jury? You recognize that?
I recognize what it is, yes.
And what is it?
It is a picture of a stomach, of the mucosa of a stomach with multiple hemorrhages.
And does that exhibit fairly and accurately depict a stomach with what you have referred to as multiple ulcers?
Yes.
Your Honor, I offer that into evidence.
I object to Anthony as a chalk.
I'll you know what? If I can use it as a chalk
Yes,
publication.
you can.
Yeah, that's what I'll do, Your Honor. Thank you, Mr. President.
So you can have it displayed.
Thank you.
The judge grabs her mic, which is
hard copy with the court reporter.
pointed way off to the side.
Oh, so it's not in evidence.
It is not.
It's marked for identification.
Yes, marked for identification, and we are with it. Mr. Wolf. Dr. Scordi-Bello, is that the depiction that you were just describing at your witness stand?
Yes.
And could you please, with the laser pointer, state what you see in this depiction?
So this is a stomach. This is the mucosa, the folds of the stomach. They're not very folded in this particular picture, but you can see these distinct areas that are that have a darker coloration. That's blood. These are hemorrhages.
And to be clear, this is not the stomach of Mr. O'Keefe. This is a medical reference depiction to sort of generic or some other depiction other than Mr. O'Keefe's stomach, correct?
Correct.
If we could, with Your Honor's permission, Mr. Wolk, put side by side this chalk with what is in evidence as the actual gastric mucosa of Mr. O'Keefe.
The objection is sustained.
Could we, with Your Honor's permission, publish simply Mr. O'Keefe's gastric mucosa?
Yes.
Isn't it correct, Dr. Scordi-Bello, that there are much less dark spots in this depiction of the gastric mucosa than there were in the chalk that we just displayed? In other words, that green depiction of what I'll just refer to as a generic stomach. Is that correct?
That is correct.
So, you can take that down, Mr. Wool. Isn't it correct that for hypothermia in the presence of Wisniewski's ulcers or spots, that you have to have a predominance of the stomach covered by the spots for them to be Wisniewski ulcers?
I think there's different levels and different grades.
In hypothermia, particularly death from hypothermia, wouldn't you expect to see a predominance of those ulcers, meaning they take up most of the stomach lining? Isn't that what you would expect to see?
Not always. I have seen that. I have also seen cases with much fewer spots, as you refer to them.
But isn't the majority of the cases that you have seen where someone has actually died from hypothermia that the ulcers predominate, take up greater than 50% of the stomach?
Yes.
And what percentage of the, and I'm trying to avoid putting it up again, so what percentage of the gastric mucosa of Mr. O'Keefe would you estimate is taken up by the ulcers that you have identified?
I would say somewhere between 10 and 15%.
Just 10 and 15%. Thank you. Now, if we could look to the issue of...
You hit Ronnie.
Continuing with hypothermia. Let's go to frostbite. Do you note any evidence of frostbite on the deceased, Mr. O'Keefe?
No, I did not.
It's the evidence of
Do
frostbite.
you know what the weather conditions were in Canton, New York on the early morning?
There's a big
I'm
sign.
saying Canton, New York. My apologies. Do you know the weather conditions in Canton, Massachusetts, starting at midnight on January 29, 2022, going through 6 a.m. on January 29, 2022?
It was very cold. There was a blizzard coming.
They called it a nor'easter, right?
Correct.
And when you say very cold, in addition to very cold, do you recall whether there were gusting winds?
I believe so.
And do you understand that when there's a very cold temperature in Fahrenheit and you add gusting winds, that is called, when you apply the two together, that's called wind chill, right?
Correct.
And with wind chill, doesn't the phenomenon of wind chill mean that the wind combined with the temperature brings the actual temperature down, and in addition to bringing it down, temperature in a wind chill calculation, it also has a physical effect on the body, correct? Wind chill. Doesn't wind chill also cause greater effects than if there was no wind?
Correct.
So in medical terms, the wind synergizes with the temperature and exacerbates the effect on a human.
Correct.
And with a wind chill, isn't it correct that you would have a greater chance of frostbite than if there was no wind chill effect at all?
Yes.
So, You saw no signs of frostbite on Mr. O'Keefe, correct?
At the time of my examination and at the time of autopsy, no, I did not.
Did you see frostbite at any other time with regard to Mr. O'Keefe?
I only examined him at the time of autopsy.
So at the only time you examined him, which is at the time of autopsy, you had 0 signs of frostbite, correct?
Correct.
Dr. Scordi-Bello, now that you have gone through your this part of your examination here today, would you like to amend in any way your opinions as to whether hypothermia was any cause of the death of Mr. O'Keefe?
No, I don't. I still believe that there were hypothermic signs.
Hypothermic signs, correct?
Yes.
I'd like to move to another topic area, please. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you?
No, I did not.
In fact, there were no injuries consistent with a motor vehicle impact on Mr. O'Keefe, correct?
Sustained.
Did you evaluate it all in your autopsy whether Mr. O'Keefe had any injuries consistent with a motor vehicle accident?
Objection. I'll allow that.
Yes, I did examine his lower extremities. That is protocol in any case of suspected impact with a motor vehicle. So I did examine his legs, and I did not see any evidence of an impact site.
And could you elaborate to the jury what you mean by no evidence of an impact site?
I'm going to sustain that objection.
What do you mean in your answer, no evidence of impact injuries?
I'll allow that.
This is big.
What I look for is some sort of bruise, either on the outside of the leg or bleeding on the inside after the skin is reflected in the soft tissues, or any fracture of the bones of the legs. I did not observe those things.
That was going to be my question. You did not observe any of those things, correct?
Correct.
Let that sink in. Pauses for dramatic effect. That was a win for defense.
I'd like to turn to, please, the face of the decedent in your analysis that you discussed on direct examination of that area of the decedent. You talked about ecchymosis, you recall that?
Yes.
In medical literature, there's a synonym for ecchymosis. It's sometimes referred to as raccoon eyes. Is that correct? Ecchymosis doesn't cause a laceration to an eyelid, does it?
No.
Ecchymosis does not cause a laceration to a nose, does it?
There was an abrasion on the nose, but no, the answer is no.
Correct. So ecchymosis doesn't cause a laceration to the nose. Correct?
Correct.
Did your report at all evaluate whether there was any significance of the laceration to the eyelid that you spoke about in your direct testimony?
What do you mean?
Other than just noting that there was a laceration to the eyelid, did your report at all evaluate the potential significance, if any, of that laceration to the eyelid?
I noted it and photographed it, and it was part of the totality of the blunt impact injuries that I noted on both the face and the head.
Do you believe that the laceration to the eyelid could be caused by a blunt impact injury?
A laceration, by definition, is a blunt impact injury.
Do you believe the eyelid laceration was caused by a blunt impact injury from falling backwards and hitting one's head?
Not from falling backwards and hitting one's head, but that area at some point came in contact with a blunt object or surface.
Okay, if I could follow up on that, please. So you agree that
CLSE,
if
please.
a person falls and hits the back of their head, that they cannot sustain an eyelid injury, is that correct?
Correct.
All right. And
Can you
if
demonstrate
somebody
that again?
falls backward and hits their head, they can't sustain from that impact to the back of the head a laceration to the nose, correct?
Correct.
So if we could, Mr. Wolk, and with Your Honor's permission, publish which is already in evidence, which are depictions. Let's start out with, please, the laceration to the right eyelid.
Lissy at night. It's a good
And Dr. Scorti-Bello, is this the laceration to the right eyelid that we've been talking about of Mr. O'Keefe?
Yes, it did. Yes, it is.
And that injury could not be caused by a fall backwards and one hitting their head, correct?
No.
I'm sorry, we'll just need, and then I'm going to repeat the question. Can you state your answer again? Let me that injury to the right eyelid, that laceration, could not be caused by someone falling backwards and hitting their head, correct?
Correct.
Bear with me one moment, Your Honor.
Something about evidence. You have to put something into evidence.
May I approach, Your Honor?
Quick reminder from Alan Jackson.
So, Mr. Brennan?
Your Honor, I erroneously assumed that that picture was in evidence, and I would like to now properly lay the foundation if I could. Okay. Dr. Scorti-Bello, you see what's in front of you. Can we mark this?
So, Mr. Brennan, are you objecting to that coming into evidence? Okay, so let's just put it in evidence.
Just put it in. Skip the foundation. There's no objection. I like that. Judge saving some time there. We saved at least 30 seconds.
Yeah, Your Honor.
Yes.
Sue O'Connell on Twitter
Dr.
reported that all the
Scorti-Bello, I
jurors are paying
placed
attention
before
to
you what
this
is in evidence
frostbite.
now is 165. And Your Honor, may I have Mr. Wolk publish
Yes.
165? Thank you, Mr. Wolk.
And the injury discussion. They're glued to this.
So, Dr. Scorti-Bello, that laceration to the right eyelid could not be caused by a fall backwards where someone hits the back of the head, correct?
Correct.
So that injury, you've called, what do you label that category? Traumatic, did you use that phraseology?
Blunt impact.
Blunt impact. So that's a blunt, in your opinion, that's a blunt impact injury, correct?
Correct.
So is it correct that that injury had to occur in some manner other than falling backwards and hitting one's head?
Yes.
And is that injury consistent or inconsistent with a punch?
I'll allow it.
Could be consistent.
Boom! That's big. That's big.
If we could, Mr. Woke, have the laceration to the nose.
Pointing out an alternate means of
I'm sorry,
acquiring
hold
these
on a
injuries. That's reasonable. You still have to get past a lot of data, a lot of phone data, temperature data, step data. You've got to be able to make everything fit together, but there could be reasonable doubt here, and this is a solid foundation to build
Mr.
that.
Brennan has agreed to stipulate this going.
Okay, so like we can mark it.
166.
Oh, thank you. Yes.
Thank you. Dr. Scordi-Bello, I have put before you what is in evidence is 166, and Your Honor may, Mr. Wolf, publish.
Yes.
Thank you. Dr. Scordi-Bello, does that exhibit fairly and accurately depict the laceration to the nose of Mr. O'Keefe?
Yeah, it's an abrasion. I described it as an abrasion, as a scrape.
So you would classify that as a scrape?
Yes.
That scrape could not be caused by someone falling backwards and hitting the back of their head, could it?
Not by a single event, no.
You can take that down, Mr. Wolf.
This testimony
on your
came in last
direct
time as well.
testimony, you talked about injuries to the right arm of Mr. O'Keefe. Do you recall that?
Yes, I do.
And is it correct that you, in your autopsy report, did not determine the cause of those wounds to Mr. O'Keefe's right arm?
That's correct.
With Your Honor's permission, I would like to Mr. Brennan.
It's more with Mr. Brennan's permission than Your Honor's, but
Your Honor, Mr. Brennan has agreed to stipulate into evidence these two photographs. May I please have them marked as next to evidence?
Exhibits 167 and 168.
Thank you.
I'm going to do the same thing, if I may, Dr. Scordi-Bello. I'm going to leave these with you, but I'm also going to, with the court's permission, have them published.
Okay.
Use whatever one best allow you to answer the question. Your Honor, may I have Mr. Wolf publish those two? Thank you. With regard to what is on the screen, am I correct that you noted these injuries to and these wounds to Mr. O'Keefe in your autopsy report?
Yes.
And am I correct that you noted that there was a pattern to those wounds?
Correct.
And although you noted there was a pattern to the wounds, you were not able to determine the cause of those pattern wounds. Is that correct?
That's correct.
Are those injuries consistent with a dog bite?
Based on our answer to the last question, ask something else.
I'm sorry, I couldn't hear you.
Ask another question. Sustained.
Can you
Look
identify
at the label on this
any
top left-hand
cause
corner.
of those
Look at the label.
injuries that would be
Arm with
consistent
dog
with
bite
what is
on it.
depicted on
It says arm with dog bite on the label.
objection?
So, can you answer that, Doctor?
I cannot.
You can take that.
Brendan
down.
allowed it
Thank
in. He stipulated to it.
Do you recall discussing at all on your direct examination? Well, let me ask it this way. Did you evaluate at all in your autopsy a gray hoodie sweatshirt of Mr. O'Keefe?
No, I did not.
So, were you aware that there was clothing associated with Mr. O'Keefe when he came as part of the autopsy?
He did not have any clothing that came to us. The clothing was removed at the hospital and was packaged and I believe submitted as evidence.
So the clothing of Mr. O'Keefe, a t-shirt or a hoodie, didn't make its way to you?
No.
You were unable to reach a determination as to the manner of death of Mr. O'Keefe, correct?
That is correct.
So you have doubts about the manner of death of Mr. O'Keefe, and you consider those doubts reasonable?
Sustained. Sustained.
You were not able to reach a determination as to the manner of death of Mr. O'Keefe, correct?
Correct.
And manner of death, as you've testified, includes the circumstances surrounding death in addition to the medical analysis that you performed. Okay.
I'm sustaining it, asked and answered.
Thank you for answering my questions, Dr. Scordi-Bello.
You're welcome.
Look at this. Arm with dog
Mr.
bite.
Leslie, Mr. Brennan?
Doctor, how many autopsies have you performed in your professional career?
At this point, more than 1,200.
When the person is brought to you, are they usually clothed?
It depends on the circumstances. If the person comes directly from their residence, they may or may not be clothed. If the person comes from a hospital where they went first for treatment, many times the person is unclothed. They may be wearing a hospital gown, but in most cases that clothing has already been removed.
If that clothing has already been processed, is it common that it would be brought to you for inspection?
Objection, Your Honor.
Sustained is to the point.
Is clothing that is not accompanying the person's body commonly brought to you for observation?
Objection, Your Honor.
So let's move on. Or ask it.
You were asked questions about your opinions relative to spots in the organs of Mr. O'Keefe, and you were asked about part of your statement in the grand jury. When you provide statements, is it important to have the statement in context to understand it?
Yes.
Is it important to have a complete statement rather than just part of a statement?
Yes. Yes.
And when you were asked
show
the
the picture,
question
keep the audio going.
that counsel asked you,
Top left
do you
corner.
remember that grand jury testimony you gave?
I remember it was a long time ago.
Okay.
But I do remember most of it.
Do you remember when he read part of your answer? It was in response to a grand juror's question.
Yes.
And he read part to you, right? I understand your question, and my answer is that I don't know, but given the environment, so if the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. Do you remember that?
Objection, Your Honor.
The doctor can answer that.
Do you remember Attorney Alisi read you that part of your statement?
Yes.
Do you remember that you had more to that statement that was left off when he confronted you with it?
I'm sure there's more to this.
To complete your statement, you said, but in the whole context, I believe that those are signs of hypothermia and not caused. Do you remember that completion to your statement?
Objection, Your Honor.
Sustained. You can show her the statement.
Okay. I can approach. I'm going to ask you to take a look at part of your grand jury testimony. Do you remember Attorney Alisi reading part of your answer back?
Objection, Your Honor.
So I'll strike that. Have the witness look at it and go from there.
Were you asked about your entire answer or just part of it?
Objection, Your Honor.
Sustained.
Would you read the rest of the answer that you weren't given when it was read to you?
Objection, Your Honor.
So this is phrased as refreshing recollection, so follow it appropriately.
Do you now remember there was more to your answer?
Yes.
Could you share with us the rest of your answer?
Without reading
Objection,
it.
Your Honor.
Without reading it. Turn it over. Turn the paper over, please.
I can take it on.
Ask the appropriate questions to her.
Do you remember the part that was left out?
Objection, Your Honor.
Sustained.
Does it refresh your memory to the rest of your statement to the grand jury?
At what point does he have to move on?
I'm sorry, what was your question?
After looking at this, does it refresh your memory to the rest of your statement you made to the grand jury?
Yes.
And could you share the rest of your statement with the jury, please?
The rest of the statement was that I have to take those findings in the context which was presented to me. So in the case of this particular case, those hemorrhages, in the context of a body found in the snow, I believe they were due to hypothermia.
Is your answer more complete in context?
Objection, Your Honor.
Sustained.
You were shown a photograph of two individuals that were in the room at the time of autopsy. Do you remember that photograph?
Yes, I do.
And you were asked about certain names?
Correct.
You said that there would be a log identifying names?
It would be a log, yes.
A log. Do you remember exactly who logged in to that autopsy?
No, I don't remember their names.
May I approach?
Show Mr. Lesson.
Part of the end of the report. Take a look. You have it.
Your Honor, if we need sidebar to explain, we just need a moment to take a look.
I can move on and we'll come back to it, Your Honor.
Thank you, Mr. Brown.
You mentioned that Mr. O'Keefe's body temperature was a little under 81 degrees when he was brought to the hospital?
Yes, that's what the hospital records stated.
And again, a normal body temperature is?
98 degrees.
So there was, is it fair to say there was over an 18-degree drop in his body temperature?
Correct.
You shared with us that you generally understood it was a blizzard and cold outside. Do you have any experience on how rapidly a body temperature will drop outside?
The body temperature?
Yes.
Objection, Your Honor. Scope.
No, it's within the scope. Let's see if she's got the basis right.
The rate that the body loses heat depends on a number of factors. Depends on conditions, weather conditions. It depends on the original temperature of the body, and the higher the gradient between the body temperature and the environmental temperature, the faster the drop will occur.
You were asked if there's any signs of frostbite. There was no type of freezer burns or anything on Mr. O'Keefe's body, was there?
Objection, Your Honor.
Sustained.
Was there any type of burns on his body that would suggest that he was put in some type of machine or environment where there was cooling, mechanical cooling?
Objection, Your Honor.
Sustained. Sustained. Move on, Mr. Brennan.
You were shown a photograph, a chalk, that had spots on them. Do you know where that photograph came from?
I do not.
Do you know who that was from, what person that was from?
No, I do not know the context of that picture.
Do you have any information on the circumstances which led to that condition?
I do not.
Do you have any information about what caused the condition that you saw on that chalk?
I have seen similar pictures in textbooks depicting gastric hemorrhages or Wisniewski spots.
You were asked about your role as a medical examiner, and there were a number of questions about your assessment from a legal perspective.
Yes.
You mentioned that you had information from a police report. How many police reports were you given?
There was a preliminary police report, I believe, the day of the autopsy, and communications with law enforcement in the days and weeks following.
May I approach?
Yes.
Showing you a document. Do you recognize that document?
Yes.
What is it?
This is a police report on this particular case.
Is that a police report from your file?
Yes.
And that police report, is that the police report that you considered?
Amongst other information, yes.
How many lines is that police report?
11.
What's the date and time of that police report?
This was initiated on January 29th. It says at 1941.
I have this marked for identification, Your Honor.
Okay.
May I hand the witness another document?
Let us mark it.
Oh, sorry. I may have that back.
Yeah.
Q for identification.
Thank you. May I approach, Your Honor?
Yes.
Second document, is that another document in your file?
Yes.
And is that another report that you considered?
Yes.
How many lines is that report?
5.
I'd move to have this marked for identification, please.
Okay.
Thank you.
Exhibit RR for identification.
Melanie Little on YouTube caught something on a freeze frame from the Sally
I'm
port.
going to go back to the questions I asked you about logging
I'm going to show you in just a second what it is.
I'm going to hand you a document. I'm not going to actually read it aloud. I'm just going to ask you to look at it. Does it refresh your memory on the people who attended the autopsy?
Yes.
And who were they?
I believe one person was Mr. Keefe and the other one was Mr. Corner.
Oh, really? Because Trooper Connor Keefe, said he went there by himself.
Are you part of the criminal investigation team?
No, I am not.
Did you go to the scene and evaluate any evidence?
No, I did not.
Did you do any of your own detective work or investigation in this case?
No, I did not.
So when you were asked questions about your role as the medical examiner in your medical evaluation of Mr. O'Keefe's body, you were also asked whether you considered any part of the legal aspect. Do you remember those questions?
Yes.
You were never, well, let me ask you.
Lead. Here comes the leading question. Ready?
You submitted the death certificate on April 14th?
Correct.
That is leading.
I want to talk about some of the things that you may or may not have known about or considered at the time you wrote your death certificate or filed your death certificate.
Prepare the objections from.
Were you informed or were you aware that before you filed your death certificate, there was information in the investigation that police spoke to a first responder by the name of Timothy Nuttall, who reported that the defendant...
I'm going to allow it.
That the defendant said, I hit him, I hit him, I hit him. Were you aware of that?
I became aware of it at some point.
During your 90-day window?
I believe so.
Were you aware that there was another first responder by the name of McLaughlin who provided information that the defendant said, I hit him, I hit him, I hit him, I hit him?
Yes.
Were you aware of statements made by the defendant, to Miss McCabe, that she said, may have I hit him? Did I hit him?
Objection, Your Honor. May we approach, please?
Yeah, let's approach, because we have some Sally Port video to watch while they approach. Look for Yanessi. Look how frustrated he is here. Let's see. There's Jackson. Yeah, Yanessi's not happy with this. All right. This is originally found by Melanie Little, who is in LawTube here on YouTube. Remember this video? I'm going to advance it slowly, frame by frame, from this frame to the next frame. What do you see? Did you guys see anything happen? Let me back up again. Okay, I'll do it again. Ready? Here we go. And forward, pop. Anything? No? Yeah, me neither. Next frame. Wait for it. Next frame. Pop. Gone. Yeah. Now, let me give an explanation. Oh, we have to go back to court. That was when they were fast forwarding. So what appeared to be individual frames for us.
So, jurors, I want to
seconds.
let you know that, like other evidence that was let in previously, this is not coming in for the truth of what's in the statements. It's coming in so that as it goes to Dr. Scorti-Bello's knowledge and state of mind at the time of her report.
Thank you. At the time of your death certificate that you filed, were you informed that a Jennifer McCabe had reported that the defendant said, did I hit him or could I have hit him multiple times?
Objection, Your Honor.
I'm going to allow it.
I don't believe I knew about Miss McCabe.
Did you learn that Ms. McCabe reported later that the defendant, while speaking to first responders, reported that she had hit him? Did you know that?
I was aware of that information later on.
Were you aware of the investigation regarding alcohol consumption?
Yes.
Were you aware that the police or Massachusetts State Police spoke to other witnesses about their observations that night?
About their
observations?
Yes.
Were you aware of an interview by Trooper Buchanan with firefighter Daniel Whitley on February 7, 2022?
I don't remember.
Were you aware that Mr. Whitley told the police that the defendant had expressed that she had gotten into an argument with the defendant that night?
That was part of the information I was given, yes.
Were you aware of a report from first responder Anthony Flamate about statements made by the defendant to him?
I don't recall that particular first responder, no.
Were you aware of statements provided by Kerry Roberts to the police that the defendant had called her, citing Kerry, John is dead?
Yeah, I was given that information.
And the questions of did I hit him, were you aware of that?
Yes.
Were you aware of information that troopers had an opportunity to go and speak to the defendant?
Yes.
Were you aware of the statements that she made to the troopers?
Not in detail.
Were you aware that when they spoke to her on January 29th, she informed that she had a broken taillight on her vehicle but did not know how it happened?
Objection, Your Honors.
I'll allow that.
Yes, I was provided with that information.
Were you provided the information that she had never observed John enter the residence?
I believe that was part of the original information, yes.
Were you aware that she informed, relative to the broken right taillight, she didn't know how it happened?
Yes, I was.
Were you aware that members of the Massachusetts State Police obtained John O'Keefe's phone and did a forensic data analysis on it?
I was not aware of that until much, much later.
After you filed your report?
Correct.
Were you aware of location data that was obtained from John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of healthcare data on John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of battery temperature data on Mr. O'Keefe's iPhone before you filed your death certificate?
No, I was not.
Were you aware of voice messages left on John O'Keefe's phone from the defendant before you filed your death certificate?
No, I was not.
Were you aware of text messages between the defendant and John O'Keefe before you filed your death certificate?
No.
Were you aware of statements from the defendant to various media outlets before you filed your death certificate?
No, I was not.
Did anybody ever come to you after you filed your death certificate and ask you to change it?
No.
Did anybody ever provide you any of this additional information you weren't aware of at the time, ask you to evaluate it, and then reconsider your finding?
No.
You were asked some questions about impact injuries. In your experience, are most pedestrian collisions where there's injuries to the lower legs either frontal or rear impacts?
Objection, Your Honor.
I'll allow that because I'll allow that.
Most pedestrian fatalities that we see are with impact with the front of the vehicle.
When you gave the perspective that you looked for impact injuries, was that with consideration of your experience that most collisions are frontal impact injuries?
Most collisions involve frontal impact, yes.
How about cases where you had an opportunity to observe people who sustained injuries from being clipped? Not hit, but just being clipped. Is your opinion any different in your experience?
Objection, Your Honor.
Sustained in that form.
Okay. How about a sideswipe injury? Is that different relative to your expectations to lower extremity injuries?
Objection, Your Honor.
Sustained.
A bruise on the knee, is that consistent with a sideswipe impact?
Could be.
Did you do any type of biomechanical analysis of any alleged collision in this case?
No, I did not.
ARCA did.
Were you asked to?
I'm not qualified to do that.
And so when you talk about injuries from a collision, are you in part speculating about what could happen to somebody?
Objection, Your Honor.
Sustained in that form.
Are you giving a direct opinion in this case about how the injuries were caused?
Objection, Your Honor.
Sustained.
You were asked questions about a nose laceration.
Yes.
And you offered that was not consistent with falling backwards on the head alone.
Correct.
You were asked if that was consistent with a punch.
Correct.
Objection, Your Honor.
That's not the testimony. That's your objection.
That is, Your Honor. There's not a question.
Did you provide an opinion that it could be consistent with a punch?
I did provide that opinion.
Could it be consistent with broken glass?
It's possible.
Could it be consistent with sharp shards from broken plastic?
Possible.
Could it be consistent with first aid?
I'm sorry, what was it?
Could it be consistent with first aid treatment?
Anything is possible.
Do you have any first-hand knowledge of how the laceration on the nose happened?
I do not have first-hand knowledge.
Did you know at the time you filed your death certificate that there was plastic pieces of taillight found near Mr. O'Keefe's body around 5:45 p.m. on January 29, 2022?
I do believe some of that information was communicated to us, yes.
Thank you.
All right, Mr. Lessie.
Thank you, Your Honor. Dr. Scorti-Bello, Attorney Brennan just asked you questions about alcohol consumption. You had the opportunity to evaluate the medical records of Mr. O'Keefe, correct?
Correct.
And you had, in terms of the medical records, information with regard to the medications that Mr. O'Keefe had taken, is that correct?
I believe I reviewed those records at some point prior to issuing my report, yes.
Do you recall the list of medications that were in the medical records that Mr. O'Keefe was on?
I do not recall.
If I were to show you a document, might that refresh your recollection as to the list of medications?
I'm going to allow it. Is in connection with alcohol, too, you said, right?
Correct, Your
Go right
Honor.
ahead.
Correct, because Brandon opened the door. While she looks at that, let's look at this, because we found another ghost. Ready? Ready, set, bing! There's one. And this one's looking right at the car.
May I approach, Your Honor?
Yes.
Dr. May I, Your Honor?
Yes.
Dr. Scorti-Bello, may I stand by the witness here?
Yes.
Thank you. Dr. Scorti-Bello, I am providing you with a document. Up at the top it says John O'Keefe, and I would like to draw your attention to medications. And to expedite it, I am going to focus on the fourth item on that list. Can you state what that medication is?
The fourth item is omeprazole.
Omeprazole?
Does that refresh your recollection as to one of the medications Mr. O'Keefe was on?
Yes.
And that medication is?
It's an antacid.
Right. And so omeprazole
Is the trade name of omeprazole Pepsid?
I believe so.
And Pepsid is a proton pump inhibitor?
Correct.
And a proton pump inhibitor stops the proton pump in the stomach from releasing acid, correct?
Yes.
And we're going to come back to that in just a moment, but do you also recall testifying at the grand jury with regard to alcohol consumption and potential alcohol consumption of Mr. O'Keefe?
I do remember testifying, yes.
And do you recall what your testimony was with regard to alcohol consumption and small ulcers in the stomach potentially associated with alcohol consumption?
Alcohol consumption, I don't recall my exact words at grand jury, but alcohol consumption can lead to gastric ulcers.
And alcohol consumption can lead to gastric ulcers, and what medications can treat gastric ulcers?
Well, they don't treat them, they prevent them, but that would be a proton pump inhibitor such as omeprazole.
Right. So, isn't it correct, therefore, that the ulcers that are observed in the stomach of Mr. O'Keefe that we talked about, the gastric mucosa, could have come from ulceration due to alcohol consumption?
It's possible.
As opposed to hypothermia, correct?
Correct.
Attorney Brennan asked you questions moments ago, and actually several of them, of which included the words, did I hit him, could I hit him? Do you recall those questions?
I do.
And isn't it correct that you had that information before you issued your final findings in this matter in April of 2022?
Yes, I did.
So, even though you had all that information, you still were unable to conclude the manner of death of Mr. O'Keefe, correct?
Correct.
Thank you, Dr. Scoiti-Bello.
All right, Doctor, you are all set.
Thank you, Your Honor.
I'm going to see counsel at sidebar.
All right, I've been rolling back and forth on this video. There are two times when a ghost appears. Ghost in the Sally Port is what we have here. There's one, and then later on.
I was told counsel wanted to see me at sidebar.
Wait for it. Wait for it. Wait for it. Going forward. Going forward. There's the other. This is when we were fast forwarding. So we're jumping by 13 plus seconds per frame. So nothing before, nothing after. But this is the one guy that seems to be looking right at the car. Looking right at it. Trying to check it out. So, interesting. All right. Look at the reflection in the mirror, too. I can see the reflection of the car. I wish I could get the original footage to look at. Are we supposed to see your screen? No. This is more of a talk show where I just tell you what I'm looking at. No, I apologize. Did you not see the two people? Let's see. Going back. Right here's the first one. Ready? Boom. Right about the time the snow was falling. It was the first ghost.
All right, so yours, that is it for today. I'm told that we are on schedule. So with that, I'm going to let you go a few minutes early. So please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be very careful with your social media use. So we'll see you tomorrow morning.
Rest of the jury.
Casserole. Casserole. Say casserole. Jury's headed out. Mics are hot. Anything can happen. Not quite done. Let's see.
Great, seated.
All right, so Mr. Lessie, I'll hear you.
We gotta fight.
I'll hear you, Mr. Lessie.
Thank you, Your Honor. The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welcher, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes. That
Okay.
My understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So the Commonwealth has established in reports right up until, not established, they had stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher, a trigger called 1162.2 that they had Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12:31:38 to 12:31:43. And we have been assuming that information, and this is from best memory, but I believe it's slide 137 or so, where the statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. Now, I'm just going to get it. So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12:31:43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12:32:16. And Your Honor may recall that the seconds, literally seconds, matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that
that information is literally by seconds determinative in some ways of various analyses. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 1231.38 to 1231.43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA, it's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffin's analysis. And Mr. Whiffin's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture, and we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it. And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy be that the violation, remedy be that this is not allowed, and that the Commonwealth proceed with its the information of Aperture that has been extant before the May 8th date of the report. Thank you.
All right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ACCA or have them go by their old report, right?
Right. And Your Honor, I'm going to answer your question, but with just the quick point that this is really much different than ARCA because two reasons. We are the defense, and ARCA is a rebuttal to the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you have another option.
It's not what I am saying that I am proffering. I think the only remedy here is exclusion in a Rule 14 violation.
And you're not waiving that?
Oh, I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, a continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't, given what's been going on, I haven't even had a chance to talk to ARPA at all.
All right, so tomorrow morning, let me know that. All right,
In Your Honor, I will do that, of course.
Continuance.
And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffen. I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffen based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense, in theory, is based upon that's been in existence now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's question.
all right, thank you. Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation. The Commonwealth, just like the defense, is entitled, continues to work on their case and study their case as time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. And if you recall in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time, given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as a witness they potentially called. Mr. DeSorga wrote a report, and in the report he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the text stream data, the black box data from the car, has an event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review their expert's report to see if he was accurate that the variance means that these times would never align. And that's what he did. He studied the data, he studied the waves, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned, from his opinion, is that Mr. DeSorga was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong. So then he looked at the time of the event of the ignition, on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moments when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text stream data or the black box information on the car whatsoever. It does not change ARPA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no delay. It's been a week now the defense has had this information. And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it is clarified and it is favorable for us. And so we should be able to use it.
Did you intend to use it in your case in chief, or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
My case in chief, because we now have this available data. As I said, this wasn't ambush, isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay. Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information, and he has accurately provided information, but he's got the time completely wrong and the significance respectfully completely wrong. I'm going to hit his 4 categories quickly. He said he referenced Mr. DeSorbo, who is a defense witness. Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert report within the reciprocal discovery deadline.
Okay.
And he provided that report months ago.
Okay.
So if, as I heard Attorney Brennan, he's saying the reason why we're getting something on May 8th is because Mr. Burgess supposedly is responding to that. That was months ago.
Okay.
The more apt point is, or an even more apt point is, Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DeSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A. So that's an important point with regard to Mr. DeSogra. Now I want to go to Attorney Brennan's comment about clocks are different. I agree with Attorney Brennan on that. The shortcoming for Attorney Brennan's argument, however, is that the clocks are different concept has been in existence in this case for over 6 months. I can give you by memory Mr. Whiffin's report of December of 2024, where his report went into the different clocks and what their significance was. So that is almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case. So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it. He already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of the first trial.
All right, I thought Burgess was, no?
No, neither. Okay. No one from Aperture was.
I knew Aperture was, and I thought he may have been something. The name just sounded.
Neither Burgess nor Welcher were part of the first trial, but they were retained. Aperture was retained, I believe, in October of 2024.
Okay.
And at best for the Commonwealth, Aperture had, and Mr. Burgess and Dr. Welcher had Mr. Whiffin's report that talked about the clock differences. So the clock differences cannot be, as the Commonwealth is proffering, some sort of new information that caused Aperture to provide a new report. This variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time. Mr. Burgess, in his original report months ago, has a whole section on clock drift. That's not a new concept for him. He's just changing the drift.
Okay. So what I'd like to do, because I want to address the other issue and I don't want to keep people here too long, can you wrap it up, Mr. Alessi, or is that?
In 60 seconds.
Okay.
Thank you, Your Honor.
Which means 3 minutes.
So, Your Honor, the last point I wanted to make, and I think I heard Attorney Brennan correctly, is he said he was surprised that he got this report dated May 8th. That's what I heard. So if the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding fetching reason to not allow it, because they're surprised to get it.
Fetching reason.
And I can lastly say this, Your Honor, there's nobody that's more surprised to getting this than the defendant when we got it on May 11th.
Okay. Thank you. The other issue
Did it in 30.
about calling your expert on rebuttal, Mr. Brennan, based on the late disclosure of the ARCA materials. What's your argument on that?
I won't iterate the entire past, but Your Honor has found discovery violations. Your Honor has found that I want to phrase this properly, the efforts of the defense were improper. And inevitably, we've now received an extraordinary amount of discovery on the most important issue in this case, well beyond the discovery deadlines, without any excuse. And the court, understandably, has overruled government suggestion and has stated that it is going to allow the defense to proffer 2 expert witnesses in a very complicated field, in an issue that is the heart of this case. If you're going to allow them to testify, despite the fact that we have not had adequate time to review, and to prepare, and to address it. The Commonwealth has the burden of proof. The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Wexler. As you know, he was away. He did not get a report until maybe May 7th. He did not have a chance to look at it until May 9th. An extraordinary amount of work, effort, and expense has gone into preparing our case for the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information, well beyond the simple 4 opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting, and then preparing testimony to address the claims made by the defense experts. Not to get into a battle of disparagement, but our expert has found extraordinary issues in his first reviews of material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate the failures of these ARCA witnesses. That's going to take time. You've heard from the ARCA witnesses themselves. With the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks.
The person whispering is the recorder.
Until May 7th. And so we believe we are entitled to have our expert review all the materials, do his testing, provide opinions. None of that is going to happen anytime soon, because he still has not finished reviewing all the materials. There's many, many gigabytes. He is in a difficult schedule. He is away tomorrow, Saturday. We were going to try to begin to prep at the end of the weekend. There is no way he's going to be able to testify anytime soon and have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what we would like to do is have him testify about what he has prepared, that he's had adequate time to prepare. If either of these ARCA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing the materials, actively engage his own testing now, so by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders, and so that he can then address the jury on those specific new issues. I see no other way of this expert fairly being provided, presented to the jury. The unfair prejudice cannot be cured in any other way. So we ask that he be able to continue his review, offer rebuttal opinions on anything that is new, and not to encroach on anything that's been previously provided.
Can Burgess testify after Welcher?
No. No, because Dr. Welcher relies on Shannon Burgess' information and material. It will make no sense. I thought about it. It makes no sense to the jury, his presentation, unless Shannon Burgess has an opportunity to provide the background information.
All right. Mr. Lessie, I'll hear you on this.
Thank you, Your Honor. I think and I understand that it's very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about ARPA and the information of ARPA, it's very important analytically to put them in their two proper buckets. The first bucket is the information and opinions of ARPA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on
Okay, good, because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that.
So we're focusing just on the, quote, new information bucket. Your Honor, it's very important to understand that what ARCA is doing is in response to the testing of Aperture. ARCA did not come up with new approaches. We, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward. And so what ARCA has done with the new information, new testing, is simply to rebut what Aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for Aperture. Now with regard to the time period, Your Honor has already determined what the appropriate approach is for the new information from ARCA. When Dr. Rentschler was on stand, or Dr. What you said, when can you get me the information? And they said, I think it was May 6th or May 7th, whatever, and they met the deadline. They did it. We proceeded along with the trial with that information. We complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided. I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to continue to address this matter as if the defense is making perpetual violations. There was a determination made, and then the question was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing violations. My final 2 points. What Mr. Brennan is seeking is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things, have ARCA have to come on, and then have Aperture come back and essentially have almost a rebuttal to a rebuttal as of right. I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices the defendant because it almost ipso facto gives a double rebuttal, surrebuttal to the defense. I believe, Your Honor, the final point is, if Your Honor is inclined to give Aperture more time, and I haven't even heard a deadline yet for Dr. Welcher. It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude its review of the ARCA work, and that there be a reflection that keeps the order, namely that the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And, Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
All right, so I have a question for you, Mr. Lessie. Are you still thinking that if the defense puts on a defense that will take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And not holding you to this, because obviously you have no burden. If ARCA is part of that defense, when in that week and a half time frame would that be?
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay. All right. I needed all this information now, so I appreciate it. All right. Thank you.
All rise.
Y'all go home now. It's past 4, and the judge is in a mood.
Goodbye.
Goodbye. She said something about casserole. Casserole. All right. With that, we have concluded another day in the Karen Reed trial. Spicy, spicy argument at the end. Let me tell you what just happened. The Commonwealth and the defense have been arguing back and forth about witnesses and about violations and who turned over the evidence or turned over reports late and what the punishment would be for them turning them over late. And they're pointing fingers back and forth. I thought this was sorted. I thought it was done. I thought that the Commonwealth told the judge, hey, it's not fair. And the judge said, you're right, defense, you did this wrongly. I find it was intentional. We're going to punish you. We're not allowed to mention ARCA in your open. And and she told him that like the day of the beginning of trial, punished him that way. Now, Brennan is using the same argument about the same delay to say it's not fair. We just put in new evidence because we're still doing new testing, and our guy just changed the timeline by about 30 seconds. It matters. It matters, okay? 30 seconds matters. Our guy changed the timeline by 30 seconds. And so it's not fair to let them keep this out, even though I'm nearly done with my case, and I just changed my theory on the whole thing. I think defense has a stronger argument. The burden shifting that this puts on them is this is like it rises to the appeal level, and Judge Beverly Canoni does not want that. 30 seconds does matter. What I didn't understand. 21 seconds to go. I've got 21 seconds to go. Yeah. What I didn't understand is the clock shift. I'm sorry. Try this at your next family reunion. Everybody who has a smartphone, set an alarm, an audible alarm for, 5 minutes in the future, a set time, all the same time. Everyone set it at the same time. Turn your volume up. Just set the phone on the table and wait. And you tell me if one alarm goes off 30 seconds before all the others. Because I'm going to guess it doesn't. Why? Because our phones are connected to the cell network. which has to do with precise timing. We get our time from the cellular network, which gets it from the satellites, and they are precision clocks. Time is a construct, apparently. Anyway, try it. I might be wrong. Maybe the alarm goes off, 10 minutes early for one person and 10 minutes late for somebody else. Apparently, his clock always, when somebody says your clock's always late, it means you're slow, not your clock was off. It's a nice way of saying you're running late. You should have been here before. All right, that's all. Is he saying the iPhone clock and the car clock differ? No, he's saying John's iPhone is a different clock. His iPhone is off. Are we doing this? No. Amber, yes, we did get Niece's testimony. You sent other docs. I am full. My brain is full. I had Brian Koberger in one ear all day long, and this in the other. So, my Alexa alarm and watch alarm go off apart from each other. Ari needs to release some brain fluid. Can we do a Zoom show to talk Karen Reed instead of podcast? Kaylee, here's the problem. I actually have to get ready and go help my buddy. It's great news. His cancer treatment is amazingly successful. Still has a lot of medical stuff ahead of him, but I'm going to go help him tonight. He's got some friends come over. I'd like to make the work a little bit easier, because if a lot of people show up, then light hands make, or many hands make light work. Is that what it is?
Call from
Gypsy.
Josie? Is that what I heard? Hello?
No, Gypsy. Gypsy, like gypsy. Gypsy Z.
Gypsy Z. Okay, I'm the screener.
Yeah,
I'm the screener for RA's channel. No, just kidding. How are you doing? This is RA.
You sound like RA to me. Come on now.
I'm sorry. How are you doing?
Okay. Pretty good. I've got something that I wanted to bring to the attention of people. You played the Melanie Little thing. Are you aware of a YouTuber named Good Logic?
Yes.
LAW.
Yes, I think we've been on the same live stream at one point. We were both invited as guests briefly. Yeah.
Oh, cool. Well, he has a theory that he calls the green grass theory.
Please tell me it's not about where he is right now, because I think he's watching the Diddy trial right now. So don't.
Oh, he is watching the Diddy trial, but he came up with this while he was covering the Karen Reed.
Yeah.
But he put up a video about it, and it has to do with it's short. It's like 8 minutes. But if you look up Good Logic, LAW, law,
yeah,
like legal logic. If you look that up and look up green grass theory, it's 8 minutes. It's not that long for your for our people to look at. But it has to do with if John O'Keefe was hit by Karen Reed and was laying on the grass when it was like a dusting of snow. How come there was snow underneath? How did the blood bleed into the snow?
Yeah, I think I've answered that one. I think the reason, we know that at one point Karen thought he was choking, probably from the CPR maneuvers where there was some gurgling from the blood that had drained down his nose from the injury in his throat, and so they tried to roll him over. So if there was liquid blood in his throat, it could have dripped or spilled out at that point, because it was not much snow.
Any of the pictures that you see, you don't see, and nobody testified to seeing like a patch of green grass or whatever in the shape of a body. Yeah.
Let me ask you this. I don't know from medical examiner. Is it a normal thing to drain the blood from the body during an examination or embalmment or anything?
I know. They do during embalmment.
Okay, did anyone do that and measure how much John was missing? And wonder where it went?
That's a good question. But also, if he were dead already, which I don't know whether he was actually dead. I know he was they called it, either in the ambulance or at the. I don't think they called it at the scene.
Right.
But if he were dead already, his blood would be pooling. It wouldn't be draining.
Yeah, I don't know. I'm okay with blood because we know that Karen had blood on her face, right? So we know that there was some blood that was not coagulated, that was in liquid form, and CPR was going on. It could have literally spurted out of his mouth if they forced air out of his lungs and there was blood collected in his throat. There's some things that could happen there. And I'm okay with some drops. If there was like a massive amount of blood on the snow, we have a problem. But I think there were drops of snow, and that would match up with, 6 little Solo cups with some snow and blood in them, the blood slushies.
Gotcha.
Yep.
Now, don't be getting yourself sick talking about blood now.
I won't. Thank you for the call, though. I love it. Good Logic's one of the great ones out there. He does some great work. I just can't follow the Diddy trial. I know that's...
Oh, yeah, I'm not into that. But he was losing subscribers, believe it or not.
Why?
It's crazy.
Wow.
I don't know. He was doing good coverage of it, and I was kind of split between watching the channel I normally do, which is yours, or watching his because he needed the numbers. So, but yeah, it's kind of crazy.
I love it. There are many creators out there that look at things very differently than I do things very differently than I do. Good Logic and I don't necessarily agree on all the trials that we've covered when they're the same, but I love that there are people out there that give you a different perspective.
To tell you the truth, often I would watch his coverage and then be part of the rewatch crew on yours. So because I like to watch the both days and everything, all of the chats and such.
Yeah, that's awesome. Well, thank you very much.
I'm in the chats every once in a while, but not very often.
All right, don't be a stranger. Thanks for the call.
Thank you. Bye.
All right, we'll see you. Bye-bye. All right, with that, I think we're going to wrap things up. There we go. Yeah, Diddy is too much. Greener says, I think we can cover a Diddy trial as long as we put up an occasional content warning label. Greeners, that's a little optimistic, but no, we're going to pass on that one. Several decent-sized channels talked about losing subscribers this week. Some think YouTube could be purging old accounts, bots, so hopefully that's all. I know we are super close to 65,000. Like how close? Like by 17 away. We're at 64,983. So if 17 of you who have not subscribed, click the subscribe button. We will hit 65,000. It could happen today, tomorrow. It's going to be good. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. Please stay safe till we go live again tomorrow morning with more of the Karen Reed trial. It is Friday. There is no podcast tonight. I do apologize. No podcast. You get to rewatch the salsa show. Make some salsa with that, and it'll be good. Thank you very much to our amazing mods. We really made them work today with the 2 live streams going back to back. But shout out to Red and Lois over there on Top Mark Media, as well as Samantha. Thank you for your work on the Top Mark Media channel, as well as our regular mods, all here. Thank you. You guys have a good night. Be healthy, safe, have fun, get some rest, buckle up, because we're not done. Runkle tonight sounds like a great idea. Or we might see you there. You guys have a good night. We'll see you. Bye-bye.